Yes, please call the list.
Item number 1.
It's if I may crave your lordship's indulgence, my lords, before my lords call out the list, if I can make a mention.
Sorry?
If I am permitted to make a mention for a matter to be listed for tomorrow or Monday, my lords, as is convenient.
What is the urgency?
It is an appeal, my lords. I have succeeded in the writ petition. A certiorari has been issued, my lords, in my favor, setting aside the order which I had challenged. That pertains to, my lords, affiliation of my lords, the State Golf Association. Now, after, my lords, the learned single judge has issued a writ of certiorari setting aside the impugned action, an injunction has been passed against me, my lords, from getting the relief which has been granted to me by way of the certiorari.
No, but how are you aggrieved by the order?
My lords, there's an injunction against me. Even though, my lords, I am successful in the writ, the impugned action has been set aside. Then the learned single judge, my lords, in the same breath says that, however, my lords, status quo should be maintained. And, my lords, I am still not in the office. Even though, my lords, the order by which I was disqualified has been set aside.
All right, Monday?
Monday.
You, Monday, give notice to the other side.
My lords, highly obliged.
Number 1.
My lords, this is the airport expansion matter.
Yes.
The matter has been fixed today, my lord, to review the progress report, my lord. So, action taken reports, my lord.
My lord, there are 4 steps we have to conclude, my lord, with regard to airport expansion. First is that contract for runway, my lord. The tender process has been finalized.
But what about the acquisition? Mr. Khan?
Worship, yes, we have taken it. Submitting a short action taken report.
Yes, Dr. Mazika?
My lord, there are 4 steps, my lord, we are required to complete. First is with regard to tender and contract for construction of runway and other facilities, my lord. The tender has been finalized, my lord. And now it is for financial concurrence before the competent authority. And that will be, in due course, will be granted, my
Who
lord.
will make the financial conference?
Headquarter of Airport Authority, my lord.
Airport Authority?
My lord. But before that, my lord, there are 3 more things. One is land, my lord. Land will come. The state is in the process of doing that. Third is environmental clearance, my lord. So, my lord, environmental clearance is in process. Now, this process requires public hearing, public notice, and there are certain guidelines for that, my lord. We have to follow that according to a timeline. We expect that we will be able to get environmental clearance if everything is all right by 31st of October, my lord. We are in August now. So we expect that by 31st of October, we'll get environmental clearance. So once we get environmental clearance, my lord, then only the contract can be awarded to the contractor. And at that point of time, we will
What
require.
hearing is required for environmental clearance?
Well, there's a system of public hearing, my lord. Those are the guidelines framed by Supreme Court.
Public hearing for what purpose?
Public hearing, if anyone has any objection with regard to the environmental measures taken and other things, my lord. So, my lord, we expect that we will be able to get the environmental clearance from Ministry of Environment, my lord, by 31st of October. Once we get that, my lord, we will be able to award the contract, and that is the time when we will require the land from state government, my lord. And in the meantime, the approval from DGCA also is pending, my lord. We have submitted that on the last occasion. They sought some clarification, my lord. We have replied to all those queries and submitted all the clarifications. So,
Regarding what?
Director General of Civil Aviation.
No, regarding what?
My lord, they have to give the approval for expansion of runway, my lord.
And you say that we were expecting more experience in the matter, but it appears that they are proceeding at their own pace.
DGCA covers the safety aspect of the airport, my lord, landing and other things. My lord.
Yes, please take down. This public interest litigation regarding development and expansion of the Shillong airport was entertained and being monitored by this court. Appreciating the need felt by this state for a larger and more well-equipped airport to facilitate operation of passenger jet aircrafts. Full stop. Given the present size, given the present capacity of this airport, only smaller and lighter aircrafts can operate from here. Full stop. Unless, full stop, Shillong being the capital of the state, of this rapidly growing state, unless its principal airport, unless its only airport is enabled to handle large aircrafts, full stop, a comma, it would not facilitate all-round development of the state. Paragraph 2. From time to time, we had passed orders to expedite the process of acquisition of land and for building of infrastructure for the construction of a longer and sturdier runway and for providing the required facilities for landing of larger aircraft. Paragraph. From time to time, we had sought action taken reports, the last of which was by our order dated 15 July 2025. We have received a short note from Mr. Khan, Learned Additional Advocate General, on behalf of the state, full stop. Learned Deputy Solicitor General has also made submissions. Paragraph. It appears from those submissions that although both the central and state governments are conscious of expansion of this airport, but we are afraid that the required urgency in accomplishing this task is not evident from the report received by us. Even now, the situation is that only a fund of rupees 72,17,56,237 further to a cabinet approval made on 4th June 2025 has been released to the District Rural Development Agency to purchase 11.75 acres of land from individual landowners. Full stop. There is no transfer of any piece of land till date. Full stop. Neither any agreement for sale entered into with any party. Full stop. We wonder how this transferred fund will be utilized to purchase the land and when. Note of interrogation. The army authorities have been good enough to allow some portion of land in their custody to be utilized for this purpose. But according to the report, only the exercise of demarcation of land is going on. Full stop. Nothing has been done to allocate this land and appropriate it for airport use. Paragraph. Learned Deputy Solicitor General Dr. Muzika submits that the Airports Authority of India would only be able to conclude the contract for construction of infrastructure with a contractor if environmental clearance after obtaining environmental clearance and acquisition of land for the airport purpose. Environmental clearance was expected to be obtained by 31st October. Some clearance is also required from the Director General of
Civil aviation.
Civil Aviation. Paragraph. In those circumstances, we can only direct that the above steps which are being taken in a routine manner be accelerated. Full stop. It is high time that this project which has been contemplated is completed. Paragraph. List is public interest litigation in December 2025. Action taken reports by the state and central governments should be filed in court before the returnable date.
My lord, may I just pray one thing, my lord? Any action taken reports or any reports that the respondents authorities are filing, my lord, may I direct them to file supply to me one day beforehand, my lord, because just now this report has been given here in the standing. I saw that report the last time what they have filed and today's report that has been placed before, my lord, there's no difference at all, my lord. Just change the numbers, my lord. So next time, in order for me to...
You have brought it to the notice of the court.
Yes, my lord.
You don't try to be an administrator yourself.
No, my lord. No,
Let
not at
the
all.
court take upon itself an
Yes.
inquisitorial role as it takes in a public interest litigation.
My lord.
All right.
Absolutely, my lord. Yes.
Let copies of the report be served upon the petitioner.
Yes.
At least 48 hours before the
My lord.
adjourned date for this application.
My lord. I am deeply obliged.
Number 2.
Where is the list?
Question number 9, C11.
Remind me, yeah? Disclosing whether before they do a finish with the ball. May it please your lordship.
You ended with the minority judgment of the Allahabad High Court.
That.
You're relying on a minority judgment.
I mean, the Allahabad High Court says a minority judgment can be relied upon, and therefore I will come to issue judgment. To the extent it does not contradict the majority.
Yes.
Purpose of citing the judgment was to show that a minority judgment of the Supreme Court can be relied upon as the law of the land, as the Allahabad High Court has done.
Yes, please.
Only for that purpose. But before I come to the International Spirits judgment, a small point I just want to dispose of. Basically, because I really don't think it was feasible with the time constraints to deal with all the 7 judgments cited by my learned friend for the bonded warehouse. Series of judgments were cited basically on the question, Mr. Paul cited, on the question of policy, and most of them, like Dwarkadas Marfatia and the Sri Lanka Vidyarthi, were on the question of proportionality, that a policy should be proportional both in its execution as also in its basic policy. So if a policy is arbitrary, what I think Justin Nariman has in a very favorite phrase of his called manifest arbitrariness. He's very fond of this expression, manifest arbitrariness. So manifest arbitrariness even in a policy can be interfered with. And if the policy has no nexus at all with the legislation, it can be interfered with. And if it is implemented in a manner which is discriminatory and in violation of Article 14, that implementation can be interfered with. For instance, the government council in Sri Lanka Vidyarthi, there was a government council, the law said you could terminate him without notice, that was interfered with. So in Dwarkadas Marfatia, the famous judgment of Bombay Port Trust, they had an exemption in the rent law. Lordship knows special state laws are there for some bodies like public premises. So they were exempted from the general law, so it is easy to evict for Bombay Port Trust. There also they said reason must be given because you being a public authority, this policy has to be implemented. So something must be there of arbitrariness either in the policy or the implementation or in no excess with the object. I have no dispute with any of the propositions cited by my learned friend, none whatever. My only answer is very short, that this is a case which it is very much in pursuance of the statutory power, which section 36. I have placed all the sections to show that it's within the statutory ambit. I have also placed our letter and the affidavit to show that it has a perfectly good policy objective, that is to stop the leakage of revenue and to increase the revenue, number one, from the excise point of view and from the supply point of view. By creating a central bonded warehouse, more brands are made available. I've shown that from the letters of the bonded warehouses because my learned friend is representing one association, but CBW has annexed the letters of 8 bonded warehouses, actually where they have said what are the advantages which are there. So I have justified the policy, and if your lordship feels that the policy is just and reasonable, then those cases really do not fit into the pattern. So to that extent, my lord, I have accepted the principle, but I have said they have no application to the facts of the incident case and the policy before my lord. So that's how I dispose with that point. A second point Mr. Paul has raised is that revenue leakage is impossible because from the beginning, that is before these amendments were made, the policy has already been changed so that they have to prepay. The warehouse has to prepay the excise duty to the excise department. This is a new point which he has made, which is not of course argued by the supplier. Now my respectful answer to that is very simple. The revenue, the excise inspectors which are there all over the state at the bonded warehouses and at the CBW, they are, I mean, obviously what has been already on paper paid, they are not there to check that. What they are there to check is when the supply trucks come in from the supplier, let us assume there is collusion between the supplier and some bonded warehouse, central or bond, whatever. Then what happens is, say 500 extra bottles enter the bonded warehouse. Lordship appreciates, which is not on the paper. And then those are put into the pipeline. That is why your excise inspectors are going over all over the state on the roads and in the warehouses checking to prevent that. That is the actual stock there matching the figures on the paper. Because if not, if by reason of collusion or otherwise, negligence, collusion, whatever it may be, thousands of bottles are coming into the warehouse, that is a huge evasion of excise duty. Those bottles will be regularized and put to the bonded warehouse and will reach the retailer through some system. So they are there to check that. This has always been the case. Bonded warehouses have got inspectors assigned to check this. CBW has 4 inspectors assigned to check this. So merely paying on paper the advanced excise duty does not stop the revenue leakage. Lordship will appreciate. Then we would not need any excise inspectors at all. Nothing is required. What vigilance is required? I've asked the question. They are there to stop any evasion of excise revenue by reason of, and VAT also, by reason of bottles entering the system which are evading the excise duty. That's their job. There are 4 excise inspectors attached to the CBW. There are, 20 maybe attached to this 45 bonded warehouses which are checking. That's their job. So to say that because I prepaid on paper, therefore there can't be any revenue leakage, my lord, unfortunately that's not the case. They are required. And because they're required, one of the major reasons for the policy is you have them all in one place. So the actual stock which is coming in from outside, you can check them more effectively. That's the main reason. So that's the policy reason. So I am merely answering, my lord, the points raised by my learned friend. Further point I'll come to later, this margin point, my lord, that I'll deal with in a holistic fashion, all taken together. Now may I deal with may I place this very important judgment of the international spirits, wines and spirits, which is covering many of the questions. I will cover, my lord, 4 points which your lordship has also raised and which Mr. Shah has also raised. 3-4 points are covered by this judgment. I will otherwise argue it on this. May I just formulate the 3 points which my learned friends have argued. Point 1 is that by giving CBW a monopolistic position, CBW can ensure which brands will enter the market, which brands you will release to the bonded warehouse, which brands you will not release to the bonded warehouse. You are giving them this power. And therefore, if the CBW wants, it can prefer some brands to other brands. Discrimination. This is one of the major arguments. Lordship will kindly take a note. This is one of the arguments. So that argument will be met here. And the second argument is again that the argument, so one is the argument of supply. I am not getting the proper supply because, or I may not be getting the proper supply because your people, the CBW, may be doing preferential allotment to particular bonded warehouses. Now, why the preferential allotment? My learned friend says, you have got your partners of CBW, one of them owns a bonded warehouse and they also own a supplier. So you will be pushing this supplier's brand that will go to this bonded warehouse, and you as CBW will say that, sorry, I don't have the other brands. I only have brand X, which my partner owns. This is the argument. Your Lordship will recall the argument. One of the major arguments. And therefore, this whole policy is bad because it leads to possible discrimination. One argument. Second argument, my lord, this is an area of supply. If I may say, if I may call it supply side discrimination. Borrow a term from economics, supply side discrimination. Now, next is, if I may coin another phrase, margin side discrimination. Margin side discrimination, as my learned friends contend, is the fact that you, CBW, can now squeeze the supplier for whatever margin you like. The supplier will have to pay CBW whatever margin the CBW demands because he is the boss. And the supplier will also have to pay the bonded warehouse down the road. So now the supplier has to take care of two entities. And therefore, naturally, his profit will go down. He has to make arrangement for this. Argument number 2. Argument number 3 from the side of the bonded warehouse, which is in his petition, is that my margin will be eaten up by Big Brother, the bonded warehouse, CBW. So there are interplay of 3 people here, Lordship kindly appreciates. And this is your Lordship's query also. Supplier, CBW, bonded warehouse. We don't directly come into the picture at all, the excise department. Nothing to do with this. So, my Lord, in this aspect, may I quickly place these paragraphs because this 7 or 8 paragraphs answers most of the points raised by my learned friends and also partly the points raised by this court, the queries raised by this court. May I just show your Lordship? Very quickly, my Lord.
The price fixed.
Price, I'm sorry.
The
Your
price
Lordship,
fixed
may I will show that also. Price fixed and the policy, the price is fixed by the Department of Excise. Please.
Yes.
Price is fixed by the Department of Excise.
It takes into account tax and commission? Or?
Everything. Everything from beginning to end. Price is fixed by department. The supplier gives a cost card with all the details and the final price is fixed by the department. I'll just show you a lot of the document.
It's inclusive of all taxes.
Inclusive of all taxes, including all margins, including all VAT, excise, retailer's margin, bonded warehouse margin, CBW margin, everything under the sun is in a cost card. And that cost card is presented, please.
So this is in state's affidavit.
Kindly see the state's affidavit. Let me answer this straight away. State's affidavit.
But now I suppose only GST is applicable.
What is the position?
Excise,
VAT.
Excise, no, this is excluded.
So which is?
Excise is applicable.
Excise applicable. State excise.
This is excluded from the GST.
Excluded from GST. I understand state excise. Cost card, why don't you show what the cost card? Lordship will see the cost card to give a clear impression. Give the cost card.
Because under VAT, at every stage you have to pay tax.
Yes.
From supplier to central tax. Then the central to warehouse tax and warehouse to retailer tax.
May I clarify this? Kindly see the cost card.
And the last taking into account?
Retailer's margin. The retailer, the shop owner charges the margin.
Whatever you have paid down the line is deducted and you pay the final VAT.
Yes. That kindly comes to...
But perhaps the VAT is gone now and it is GST.
My Lord, 13 September 23, kindly see this. It's important your Lordship should have the concept clear. 13 September 23, the affidavit of this CBW. At page 32, your Lordship will get the actual breakdown. An example, of course. But it will clarify how the system works. Do you have that, madam? Giving it. 13 September 23.
Affidavit.
Affidavit of 13 September 23 of Mr. Sri Neeraj Kapoor for the Central Bonded Warehouse.
Respondent number 3.
Respondent number 3. And then show the fixation.
Right. Fixation of cost price.
Page 32 will make the position absolutely clear if your Lordship comes to page 32. This is an illustrative cost card given by the CBW. You'll see all the margins, you'll see all the taxes. $32, my lord, has?
GST.
Yes. Kindly see the cost card. Ends up at maximum retail price 1600. Page 32.
Of the affidavit.
Yes.
Annexure D series.
Annexure D series.
Yes.
Yes. Lordship sees brand, variant, whiskey, so and so, so and so, so and so, so and so, so and so. MRP 1600 rupees per unit. Now, how did they come to 1600 rupees? Kindly see. Starts from the billing price, says CST landed to central bonded warehouse. From 838, it goes to 8588. Then there's a CBW margin of 10%. It comes to 9427. Then there's a bonded warehouse margin of 8%, comes to 754, goes to 10,000. Then literage fee, then ad valorem, that is the tax. Then there's VAT. Ad valorem is what? Excise. Excise is 1850. VAT is 3,600. Lordship sees it. So both the margins come in, then VAT, then excise. Then landed to retail 15,000. That's a substantial portion here. Then the retail margin 20%. The retailer is taking, the shopkeeper is taking 20%. Retail margin 20% comes to 19,000. Then there's a lifting fee of 2 rupees. Then the price comes to 19,200, which is effectively 1,600 per unit. This will give your lordship all the elements which go to make the maximum price, MRP. Lordship is, I believe this is quite clear. So this is how it is broken up. All the elements are taken into account when the supplier gives this cost card. It's a back calculation. And the MRP is fixed by the government. That your lordship will get, I believe is not an issue. But anyway, I'm showing it for your lordship for
in the
state's affidavit of
5th October 2021.
5th October 2021. Okay.
Annexure R4.
5th October 21 of the state, my lord.
Annexure R4.
Annexure R4. Got it? And where is that neighboring state business? The application.
This bond margin includes central warehouses margin
Yes,
also?
yes. 10% kindly says. In this case, it's marked there.
And what about the general warehouses, their margin?
8% is written there. Take it out again. It's there, it's there. Your lordship sees it. Entry number, I'll go back to that.
Retail margin, I can see 20%.
I'll just
Bond
give me a minute.
margin,
Lordship
10.
gives me a minute.
Bond margins 10%.
Bond margin 10%. Where is that document? Yes, yes. Yes. Now, bond margin CBW 838 rupees. The percentage is 10%. Lordship gets it? Middle of the page. Percentage bond margin 10%.
Yes,
That is the CBW. 838 rupees.
yes.
So that is inclusive of both.
I'm sorry. My line friend says it's inclusive of both.
8 and 2 minutes.
8 and 2. But then there's a further margin here, if you kindly see. DB margin of 754 rupees. Under the amendment, 8% is given to my learned friend's client. That is a DB margin, 754 rupees. So subject to correction, I believe there are two margins here. One 10% and one the second margin of 754 rupees. First margin is 838 rupees.
Their association president,
Yeah.
in his letter, is saying that you absorb this in your tax.
Very well. We'll come to that argument. Oh, yes, yeah. I should absorb.
Yes.
Yes, of course, yes. Revenue will absorb after the policy is in the interest of the public. The revenue will absorb the supplier's loss. I find it incredible
Not the
suggestion.
supplier's loss, the commission.
Yeah, that's what I mean. That's the supplier's loss. The commission is the supplier's loss.
If you see the reply to the letter,
Yes.
the reply to the reply or the first letter, I don't remember, that whatever extra amount would be payable by this notification to the,
You pay. You absorb it in your revenue.
you paid from your revenue.
Yeah, that's right.
That is one of the
If your lordship is going to direct excise duty reduction, please appreciate what is happening. Excise duty reduction in order to offset the loss of profit of the supplier, my lord, that will be incredible. My lord, I think that will upend the whole concept of public interest. For the benefit of a private supplier, the revenue, excise revenue, tax will go down because I can only levy tax. So I am being asked to reduce my level of tax so that he takes care of his commission, which I think, my lord, no court should possibly accede to that. But here your lordship will get the margins. I'm going to check for it. I think it is 2 margins possible. So, in any event, my lord, let me now deal with this paragraphs here, which will deal with some of the questions, and I will further develop my most important part will be the queries which have fallen from your lord regarding this margin, discrimination, other things, my lord. I'll deal with that. Now, if your lordship kindly sees this judgment, because this judgment has answered at least 3 of the points raised. So, kindly come to paragraph 46 onwards. Only 5 paragraphs I'll place. Kindly see. Each paragraph is vital. I have not placed any judgments unless it's vital. My lord, this is very vital. Paragraph 46. Last time I gave it to your lordship. You have the copy, right? My lord, para 46. I thought I argued Article 19. I placed this para 46. Yeah.
We have this
Yes.
for tomorrow also.
It was not completed.
Yeah, but I placed 46. I think I placed, your lordship has para 46? Last time I placed it, I will not repeat it. This is the Article 19 point.
43 onwards you have placed.
Yes, very well. Now, kindly come.
48 also.
Yes. Now, lordship kindly comes to 49. Very important, 49, para 49. Exactly, Mr. Gopal Subramaniam, making exactly the argument which is being made now, today. In this 49 paragraph. In this case, Mr. Gopal Subramaniam, learned senior counsel, etc., their license be acting unfairly. It is the case of the appellant that the sole licensee can misuse his position in at least 3 ways. Kindly note. 1. It is contended, it is possible, italics, it is possible. Licensee prefers certain brands to others. Inasmuch as concern negotiations, longer credit period, other terms and conditions. BIO supplies the mercy of the licensee with no option but to reconcile the terms and conditions laid down by the licensee. So here also Mr. Shah argued that you will have the monopolistic condition of position of being able to negotiate. 2. Failure to adhere with the terms and conditions may result in a situation particular brand will not be made available in Haryana. In view of the monopolistic position, it may choose to, kindly see, is very important. If your lordship makes a note. It may choose to promote certain brands over others on account of unfair negotiating position. Kindly makes a note of this, para 49. Exactly what is argued. That you, CBW, will prefer certain brands when people come to you, indenting officer from BW will say, no, I don't have the brand, please take my friend's brand. This is specifically raised here. Though the condition provided has to supply goods demanded, there are no means by which actual demand is sustained. It is open to the licensee to offer discounts to retailer it seeks to favor. Same argument made here. Lordship also made with the query that I've just got it from the recording in the YouTube, that they may be having more play in the joints market, they may be able to negotiate. This has all been argued at para 49. Relating to this relies on neutralizing condition regarding the maximum sale price, etc. So 49 is very important. Then 52. Kindly come to 52. 51, pleading in this case is conspicuous by its absence. Here also, kindly appreciate, very important. I'll come to the other cases which my learned friend has cited, they actually support me. If you make a case before this court, that look here, I am showing you on the figures, my supply of these brands has gone down. Your policy is favoring X brand. My brand has gone down. I am losing. My indents are being made on CBW. You are not honoring the indents. My production, my sales are going down. Your lordship is not only required but bound to interfere. if I make the case, pleadings and absence, if I make the case that a particular supplier for international spirits, that you CBW are not honoring the intents for my brand is going down in market, you are favoring brands of others, the figures have to be there. Then your lordship will of course act in this policy. As your lordship says, tweak the policy. Your lordship will tweak the policy. Your lordship will give a direction that on these figures, you are required to supply every month so much in the indent. That has been done in Chhattisgarh case. Your lordship will say that why the stocks, because here the stocks are supposed to be for 1 month of every brand. Your lordship would say, and in the other case, that publish the monthly stocks. Let us see what the monthly stocks are. Indents are not being met. I will give direction to indents. A lot can be done within this policy, which has been done in those 2 high courts. Those 2 high courts did not strike down the policy. Those 2 high courts cited did not strike down the policy. They made sure that the policy where it was being misused by the authority was made to be used properly. I'll show your lordship. Now kindly come to para 52. Para 52. This case before Supreme Court was a much better case than the case before this court. It was a better case, but still they lost. Para 52. Kindly note the facts in para 52. The appellant would point out that in fact, after the new regime has been put in place, 5-star hotels were not being provided sufficient stock of the BIO products of the members of the appellant. Lordship sees. So they made the case. It has been pointed out immediately after grant of license, there has been sudden decline in the sales of products supplied by members of the appellant. The reason for the decline is sought to be placed at the doorstep of the sole license. That would be CBW here. The appellant has pointed out sudden decline of 25% in the supply of BIO brands of United Spirits. There is a 30% decline in the BIO products of Pernod Ricard. There is significant rise in the products of Pernod Ricard in the neighboring states of Rajasthan and Delhi. Kindly note this. So material was given to the Supreme Court that look here, this licensee, my sales have dropped, Pernod Ricard sales have dropped, my sales have dropped, they have gone up in the neighboring states because this fellow, this licensee is not giving me stocks properly. They gave the figures. Here they have given nothing. Zero. We are expected to believe that it might happen sometime in the future. But here in the Supreme Court, they gave the actual figures. At para 52. My lord, point to point the Supreme Court has dealt with the points. My lord, 53. Each line is important, not each paragraph, each line. Kindly see para 53. I would notice that many of the contentions of the appellant are in the form of apprehension about what may happen in future. Kindly see the line. In fact, there is a case for the respondent that no complaint as such was moved against the licensee during the period. The licensee is duty bound on the term, the condition to submit pricing of each brand at the time of approval of the brand. The department is bound to approve the maximum sale price, factoring certain elements. Licensee must indicate landing price, expense, profit margins. Price is determined based on the prevailing rates of the same and equivalent rate of the neighboring states. Here also, my lord, it is a admitted position. I don't want to trouble my lord with the document. We are fixed a maximum retail price as per the price of the neighboring state, Assam. And the reason I tell your lordship, if I fix my price higher, there will be interstate smuggling. So we keep it at the same rate. Admitted, it's in the document, Mr. Shahaz also. So we are fixed MRP just below the price of the neighboring state, Assam. Next, furthermore, so in paragraph 53, the Supreme Court notes that this is apprehension but what may happen in future, there is no complaint. Now may I ask myself the question, where is the complaint here in this case? One single letter that supply has not been given. One single letter that you are preferring the suppliers of my rivals to me. One single letter to the government that this CBW is practicing discrimination, not giving me my indent, so on and so forth, which I am losing business. Complaint to the government. Nothing is there. Zero. It's all in apprehension in future. May happen sometime. So the Supreme Court is saying, paragraph 53, this will not do. This will not do. Next, the licensee is under the conditions required to keep sufficient stock of brands. All brands are registered with the department. there are at least two restrictions exist as safeguards which operate against the exclusive licensee. Licensee is obliged to keep sufficient number of stock of all brands. Kindly note, here also the rule provides 1 month stock of all brand. Kindly makes a note. Every single brand is registered by Mr. Shah's client with the government, and every single brand 1 month stock is required. I understand they take that 1 month stock on the basis of the previous month's consumption. But I have not seen, a lot has been said, guidelines and all this, that. I have not seen a single letter complaining that my stock has not been, the indent has not been honored. Not a single letter. All in theory. Then, the members of the parliament following the expression procuring licenses. Regulation of the maximum price which the exclusive licensee can demand. This is also here. A question may arise. However, no doubt what would happen, the exclusive licensee himself also operates retail outlets and promotes certain brands or dampens the trade in others. Lordship has the line. Kindly see the line, my lord, it's important. The same question raised in this case, that you are promoting your favorites because your partners are also partners of the supplier and the bonded warehouse. Same question. In the first place, I think ordinarily on the principle, a person acting in sole self-interest, there is no reason for the licensee to deny himself the proceeds of higher turnover based on more sale by seeking to dampen the sale of certain brands. My lord, what is he saying? I tell you, lordship. Supposing I am CBW. Now, Mr. Shah's brand, let us assume, is Old Monk. Now, Old Monk rum. Mr. Shah's intent is for, through the indentor, is for Old Monk rum. CBW prefers McDowell rum because CBW partner is the owner of McDowell rum. This is the possible conflict which might happen. Now, what the Supreme Court is saying, if Old Monk rum is what the public wants, giving McDowell rum will not do. You will lose money because Old Monk rum is the rum which will sell. And the margin is dependent, the money you make is dependent upon your sales. Selling a bogus, I don't say bogus, a less selling item will not get you that amount of money. So the CBW will be cutting its own throat in promoting a brand which is not selling in the market. This is what the Supreme Court is saying. Even if it is my partner selling it, if it's not going to sell in the market, ultimately it has to sell at the retail shop, then it's not going to work for me. That's the first contention of the Supreme Court, the first point the Supreme Court has said. Then, I must remind myself that, let us assume, however, that is placed in a situation of conflict of interest by suppressing the sale of certain brands, while permitting the sale of other brands, the exclusive license is placed in a more advantageous position, prefers it. I must remind myself, the complaint of the individual company would be that brand it wishes to import and deal is not made available. So the complaint is, Mr. Shah has to say, I have this brand, is not being made available. Quite clearly, this would be an infraction of the condition of license. Authorities will take suitable action in appropriate cases, cancel the license. So what is the remedy? If I behave in this, not I, the CBW behaves in this unfortunate fashion of not honoring the indents, preferring certain suppliers, what is the remedy? The license will be cancelled. You complain to the government. You are not honoring the indents, the license will be cancelled. That's the remedy which the Supreme Court says. Then, I must remind myself, the state has apparently gained by way of revenue by the new regime. Power to experiment in economic matters shall not, this is on a different question, the last paragraph, that the revenue increase, which is there in this case also I've shown in the additional affidavit. So this is a good enough reason for economic policy, but that's on a different point, also relevant. But all these questions are dealing with what? Safeguards are there. Kindly note the safeguards. Number one, MRP is fixed by the state, neighboring state. So that is fixed. Number two, supply is also subject to, if there's a discrimination in supply, your remedy is to make the complaint and complain to the government, which will cancel the license. Number 2 point. Number 3 point is, it is unlikely such a thing will happen because you'll be cutting your own throat. Economically, you will suffer loss. May I just show your lordship in this context the relevant policy which, just very quickly, your lordship need not be troubled. I'll just give the paragraph. Number, your lordship has heard it.
Yes.
What are the safeguards? Bonded warehouse has got 8% under the statute. Maximum retail price is fixed. Stock is 1 month stock of all brands registered by the supplier. So his stock is clear. His delivery period is fixed. Within 60 days, I have to give the...
Like this, Mr. Banerjee, as I've understood it now.
Right. So now may I go to the next question, which your lordship... Yeah.
you are at liberty to buy anything you want from any shop or market.
Yes. No, no.
Now
Here,
suppose-
may I?
Now suppose, let me finish. Now the law or rule or notification comes that you will only buy it from something like a ration shop,
No.
All right.
I'm sorry, my lord.
No, please.
I will explain this.
which will have everything.
May I?
What you get in the market, open market, it will have everything. Now, you go to the ration shop, and you
Yes.
are very fond of fresh meat.
Yes.
You are told, no, we don't have fresh meat, we only have sausages. You take this, it is not available. It is not possible for you to check that out. That is number one point. And number two, the new shop owner or the licensee, if he gets more commission out of sausage, he will say that, no, it is you take that, but the other thing is forever not available in the market and promote that. For example, you want basmati rice. You say, I want ITC basmati. They say, no, that is not available. Something else is available. Kohinoor is available. You take Kohinoor because he gets more commission out of that. So this is kind of
What is my learning? What is
the
troubling here?
anticipation.
May I answer this?
There is everything he's supposed to keep. But then what he will keep and what he will not keep and what he will regulate and what he will sell and not sell will not be in your hand.
Very well. May I answer?
Before that, everything was in your control.
Very well. No, with respect, my lord, I believe there is some slight. May I explain? May I just give your lordship this? They give it now or later? Let me explain first. May I
As
explain?
I told you earlier,
May I explain?
it is
What-
not more in the policy. Policy, you have to see on the face of it.
Yes,
And there is another thing called working out of that policy.
absolutely. Absolutely.
Or rather, tweaking of the policy.
Very well. Let us see, my lord, how the policy is valid, how is to be tweaked and all that. I'll come to that, my lord.
Yes.
Yes. But first
No,
and foremost, may I give your lordship, my
You
lord?
need not you need not come to that because if it is not tweaked properly, then a fresh cause of action will arise.
That's right. No, may I indicate a few things, my lord? It is not that the bonded warehouse, I believe now I'm looking at it from the point of view of the bonded warehouse.
Yes.
We'll come to the supplier later because your lordship's query is, if I have understood it properly, your lordship will correct me, from the bonded warehouse point of view, the choice of the bonded warehouse, right?
Yes.
All right. Now, may I just indicate what was the situation before and what is the situation after?
Not the choice of the bonded warehouse. The trade in general. Before the notification.
The trade in
after
general.
yes.
The trade in general. May I explain the trade in general? Then may I just give your lordship two flow charts, my lord?
It becomes kind of Russian kind of trade through a
Yes, just give it.
cooperative kind of.
Yes, I will give your lordship, my lord, two flow charts, my lord, in answer to your lordship's query. 2 plus 2, huh? We'll go for the anticipated demand.
Yes.
Hmm? You better give him a copy. First of all. May I give your lordship the flowchart, my lord? I believe this aspect has to be made very clear before my lord. The actual working of the system. Kindly appreciate. Give me 5 minutes, I'll clarify the whole thing. Now, let's take the position before and after. So before, what my learned friends were very happy with apparently. At least the supplier was happy with. What was the situation before? Now, please appreciate, the choice of the brand is only with the retailer. No other person has a choice of brand. The retailer is the person, the man in the shop. Sitting in Shillong, he decides what the public wants. So, he decides Old Monk rum is the rum which the public wants. 5 different suppliers may make Old Monk rum. He decides that Old Monk rum is what the public wants. Choice is his. First is market demand. My lord, lot has been said about market demand. Let us be very clear about what is market demand. Market demand is what the person going down the road goes to the shop and wants. Right? So let us say market demand is that International Spirits or Pernod Ricard's brand, whatever the brand, let us take for example, Imperial Blue is their brand, is it? ISW? Imperial Blue, right?
Right.
Say Imperial Blue whiskey, whatever. I'm not so conversed. Huh? Pernod Ricard. Imperial Blue whiskey is what the public wants. Now, what will happen? This is before the amendment, please. What I'm trying to clarify this choice point from your lordships, what you get. What the retailer will ask the bonded warehouse, please supply me 50 crates of Imperial Blue. Kindly appreciate. I've given your lordship the chart. Indent is by the retailer on the bonded warehouse. Bonded warehouse has to supply to the retailer 50 crates of Imperial Blue. Or 5 crates or whatever. Now the bonded warehouse, therefore, has to contact the one supplier who sells Imperial Blue. That man and only that man. The bonded warehouse is only a warehouse, please appreciate. The bonded warehouse has not got the choice. He has to contact the owner of Imperial Blue supplier, sitting in Haryana, one person.
Manufacturer.
One man. The manufacturer of that brand. No choice with the bonded warehouse at any stage. Kindly, this is what I've tried to impress over my lord. The retailer says, I want this product of Pernod Ricard or whatever it is. Then you, the bonded warehouse, contact that man and that thing is given to you, sent to you, you pay whatever, and you supply it. I'm telling your lordship the process. We'll come to the finance later.
Or an order can be placed on Mr. Shah's client. The bottler supplier.
Yes, only, not or, only. There is only one supplier for each brand. One supplier, one brand. That's why I want to make it clear. That brand, Mr. Shah's client, one supplier, registered with the government, price fixed with the government, Old Mangram, made in Solan, by that supplier, one supplier in India. Owning one trademark, whatever it is. So that one supplier of that, there is only one man who will make that Old Man rum. Not two, not three.
Which may be procured by the International Spirits Association.
Yes, no, they are the owners, they are the suppliers.
But they are not the manufacturers. They are
They are the manufacturers. Yes.
of these brands.
Yes, all these brands, they are the manufacturers. I can give a lordship the bottles where it is all over India. They are the manufacturers. Except those imported brands which come, BIO, those I leave out for the time being, some Scotch whiskies from Scotland. But by and large, Indian made foreign liquor.
No, BIO I looked up. It is that Ayurveda something.
No, BIO is bottled in import. The expression is referred in excise, in this parlance, liquor trade parlance. BIO means bottled in import, means those bottles which are coming from foreign lands. Bottled in origin means you are bottling Glenlivet in somewhere in Scotland and they import it directly. That's bottled in origin. But all of it is imported into Meghalaya, of course, in that sense.
So that is also covered by this notification.
Yes. All covered. Now, regarding the Indian brand, so to speak, they are all being produced by international spirits within India. So, sorry? 70%, my life. Rest is outside. Some is outside, 30% which is imported from abroad, 70% is in India. We are concerned with the ones in India for the time being. These 70%, I have to place an order for this brand on that international spirits. Let us assume whether they're the manufacturer or the importer from abroad comes to the same thing. Single point. Let us not get into this confusion. Single point, somewhere in Gurgaon, international spirits is procuring, or in Himachal, Old Monk rum and sending it to the bonded warehouse. My lord, am I clear? There is no question of choice. The warehouse has not got the choice of some other rum. He has to select that rum which the retailer has asked him to supply, because that is what the consumer wants. This is scenario A. In this scenario, the supplier, international spirits, will give some commission margin to the bonded warehouse. Scenario 1. Now scenario 2. The new scenario. Scenario 2 is, now the bonded warehouse will not take the supply from the supplier directly. But the retailer will still make the demand on the indent on the bonded warehouse. He is in Meghalaya. Now what he will do, he will raise an indent for that same Old Monk rum, now not on the supplier, but on the CBW.
Got it, Mr. Banerjee, but...
No, man. Because your lordship's point was different types of fish and all that.
Not different
one type of fish. It is only Hilsa. He is buying Hilsa again.
Before that, the bonded warehouse would have an option of exploring A, B, C, D up to Z.
No,
supplier.
no, with respect, no. There is no option. Bonded warehouse has, that's why I'm trying to explain.
Before.
Bonded warehouse, before also, he has to buy from that one supplier. There is no option for the bonded warehouse. That's why I want to make clear. There is maybe some misconception. I have not been able to explain myself. Before also, we are taking before. One supplier and one supplier only will supply that brand to the bonded warehouse. Not, the bonded warehouse cannot take a choice. Okay, from this supplier, maybe I don't like Old Monk rum. I think McDowell's Premier, I'll take from another supplier. No. He has only that one choice. The choice is the choice of the market.
It's not by description, but by trade name.
Trade name, yes. Market is the trade name. The man on the road, the shop on the road tells him, Mr. Bonded Warehouse, I want Pernod Ricard's, whatever, Imperial Blue, whatever it is. I want that Imperial Blue that is made by Pernod Ricard, and that is supplied from only one point, and that Pernod Ricard will supply to you. The warehouse has not got the option to go to any other supplier for rum or anything else. He has to go to the same supplier. So that choice of, because your lordship was proceeding on the basis that earlier he had a choice of Hilsa and Vetke and prawn, with respect. He has only the choice of prawn. He had always the choice of prawn. Now instead of the prawn being given by Mr. Banerjee, now the prawn is given by Mr. Shah. That's it. He has to be, instead of that prawn coming from X to one person, it is coming to another person. Earlier, X is to supply to him. Now X is to supply to the CBW.
Take it in lighter vein.
Yeah.
If Mr. Shah says, the prawn nahi mila, then
All right.
Mr. Banerjee will take Hilsa instead of prawn.
No,
And thereby the market
no,
will be...
Mr. Banerjee will not. Mr. Banerjee will complain to the government, I'm not getting my prawn and your license will be cancelled. That's what Mr. Banerjee will do. I will not accept it. I will not accept it. Now kindly see that the chart. If you see the chart in detail, the indent is placed. There are two charts. One is anticipated, one is actual. I tell you lordship difference. Actual is a new product, so it starts from the beginning. Anticipated is the normal, which is on 1 month's previous month's supply. That's the only difference.
Yes.
But you will see, indent is made by the retail shop on the bonded warehouse. In earlier case, now also. Difference is only this. The product is also the same. Kindly see. I'll tell your lordship what may be argued against me. Difference is, he could negotiate maybe some, which argument was noted in that judgment. Maybe if he had negotiated directly with the supplier, he could have got some better margin or something, or credit supply. Now he has to negotiate that commercial arrangement with CBW. That's the net and total difference before.
Yes.
The stock, the material is exactly the same.
Price also.
Price is exactly the same. MRP fixed. So there is no impact on supply at all. Rather, he is better off now because today, under the current law, the CBW has to keep 1 month stock at all times. That's the statute. 1 month stock is the rule. If he does not keep 1 month stock, then he can be pulled up by the supplier. That was not the case earlier. Kindly see the safeguards which have been introduced. Why it is unfair, I would say, for them to complain. It is a much better regime. 1 month stock he has to have. So his rum has to be there because he has registered his brand. 1 month stock of the Old Monk rum has to be there. Number one. Now if the indenter wants supply from the Old Monk, the CBW cannot refuse because the indent, that fellow is not indenting any other supply. If he comes, then what your lordship is saying, if he asks CBW, give me this Old Monk rum, and CBW says, no, I don't have it, I will take some other rum, then he will be in violation of the law because he has to honor the indent of the bonded warehouse. And he has to do it because 1 month stock has to be with him. He cannot in law, in view of that regulation, say that I don't have stock. Regulation is very clear. 1 month, 3 month stock.
We have seen that.
So then if under the law, the CBW...
3 months, 1 month, etc., you have to keep the
Yeah, no, I have to keep 1 month stock and in 60 days I have to deliver. Both. I have to keep the stock and the delivery. Nothing was there earlier. Earlier regime, there was no need for me to keep any stock. So now, kindly see, this whole argument is completely fallacious. Who will raise the bond? The bonded warehouse is raising an indent for the rum on the CBW. What is the argument? CBW will say, I don't have this. Take something else. That has fallen from your lordship. And that has fallen from Mr. Shah. It can't be, I tell your lordship. Because when the BW says to CBW, give me this, if he says I don't have it, he's in violation of the regulation which says he must have 1 month stock. That regulation is, what regulation number? I just... Regulation, yes. The central bonded warehouse shall have a minimum stock of all types of brands for 1 month at any point of time, so that continuous regular supply can be maintained to all bonded warehouse throughout the state. Regulation number 10. So I cannot, at the bonded warehouse, if I do not give him the stock, I am in violation of regulation number 10. Where is the question of my saying I don't have the stock? I want take something else. Why should I take something else? The regulation says you're bound to have the stock. And the further regulation says in regulation 9 that capacity to supply and deliver 45 days all goods in the state, 60 days of goods are imported outside. So not only must you have the stock, you must deliver it within 60 days. So where is the question of CBWD saying, I don't have stock, I will give you something else? Can't be done, because if he does, he's in violation of 2 regulations. So write to us, we'll cancel the license. Tell us he's not maintaining the stock. Tell us he's not giving you the supply. We'll cancel the license. Is there, my lord, not a single complaint over these 4 years? This CBW has been functioning for 4 years. Not a single complaint that supply has not been given. Not a single complaint somebody has been favored. Everything is in the hot air.
You got the point. We'll continue tomorrow?
Tomorrow, man. I'll address your lordship on the margin and close, man.
Yes. Tomorrow, yes. It's like this, Mr. Maji, we've understood it more, not on the face of the notification, but on the working of it.
Yeah, that's why I'm explaining the working. And I'll also suggest some possible measures in which your lordship can protect the interest.
Suppose the fee that you get for each appearance is, say, inclusive of clerkage. Say, so much. Now comes a notification from the government that you have to engage a peon also, who will just have the task of receiving the brief. And so much of the clerkage will go to it.
I will address that question tomorrow.
All the clerks will file a petition that he is doing no work. Why should I lose?
My lord, this happened to us in the legal profession when they put a professional tax on us in addition to income tax. And it was argued for the lawyers, I believe, that why a professional tax? We are already paying income tax. But if the government imposed a professional tax on us in addition to income tax, we had to pay this.
So
that was also equally unfair, my lord. Government imposing professional tax on people who are working hard and paying 40%, 45% income tax. But we still had to pay that one.
Big business, big deal. But the core point is this.
Very well.
Clerk and peon
I am obliged. So
sharing the clerkage.
Your lordship is this supply and discrimination point is over. Now I only deal with this one.
So we have to see that whether it violates Article 14, 19.
Very well. I'll address your lordship.
All those big expressions used in our jurisprudence.
The margin. Very well. Tomorrow I'll only address your lordship.
You have to go by the facts of the case.
My lord.
Well, it's if I may just crave your lordship's indulgence,
yes.
It's item 8, which is that my lords have said that will be taken up tomorrow with my learned seniors.
I would like to complete tomorrow. Your lordship kindly give me some precedence so that.
Well,
what is item 8? That cement factory?
No, my lords. Item 8 is my lords would reflect conclusion of contract by that LOA. Well, it's whether written agreement is required or not required. My lords have taken a view, my lords, this is not required, and some interim orders in the past. May I pray, my lords, if this matters can be taken up on next week sometime, my lords, subject to your laws.
Let it be in the list. If it is called on, one of your juniors can make the prayer, we will do it.
My lords. Obliged.
Grateful.